101. Under what circumstances may the Sestuique Trust give consent to an act by the trustee, where all of them are of full age and under no legal disability? Sui juris. They may consent and cannot after be heard to complain, but if only some of several have consented, the ones who have not consented are entitled to be indemnified for their loss. 102. On what does the extent of the remedy in equity depend? The character of the wrong done. An act of misfeasance or nonfeasance will subject the trustee only to the actual loss, but if it be an act of malfeasance, he is liable not only for the loss, but also may be made to account for the profits with interest. 103. What is a public or charitable trust? One where the legal ownership is conferred on a fiduciary holder with a trust for general objects, and not for the benefit of a specific owner. 104. In what sense is the word charity applied to trusts? The definition of Mr. Justice Gray in Jackson vs. Phillips, 14 Allen, 539, is a gift to be applied consistently with existing law for the benefit of an indefinite number of persons, either by bringing their minds or hearts under the influence of education or religion, by relieving their bodies from disease, suffering, or restraint, by assisting them to establish themselves in life, or by erecting or maintaining public works or otherwise lessening the burdens of government. For other definitions see Jones vs. Williams, Amble, 652. Mr. Binney in the Girard case, 2 Howe, 128, and Erskine vs. Whitehead, 84. Indiana, 357. 105. What was the statute of charitable uses? 43. Illers, ch. 4, 1601, in which are enumerated the purposes of charity. See Adams pp. 66. 106. What is a superstitious use? Where a trust is created for the maintenance of a priest to pray for the soul of the donor, but it has been held that there are no such in the United States. See Methodist Church vs. Remington, 1 Watts, 218, Ex parte Schooler, 134. Mass, 426, although a device to infidel societies. Zazis vs. James, 63 Penn State, 465. And in Hutchins vs. George, 44, N. J. Ec. Sec. 124, were null and void. 107. What was the old rule as to the time when a charitable trust must have been created? It must have been made if of real estate, or estates savouring of the realty, by an indenture 12 months prior to the death of the donor. 6 Geo. 2, 1765, under the law by Sec. 1635, D.C. Code. Bequests for religious purposes in trust are not valid unless made at least 1 calendar month before the death of the testator. 108. What are the principal distinctions between private trusts and charitable trusts? 1. Charitable trusts are not affected by lapse of time. 2. Where the object of a charitable trust has failed, it will be given effect by the Cypress doctrine. 109. What do you understand by the rule that charitable trusts are not affected by the lapse of time? A private trust cannot be created to exist for a longer period than a life or lives in being and 21 years thereafter, but a public trust may have an indefinite duration of time, and the rule of perpetuities will have no effect on it. 110. What is the Cypress doctrine? Wherever a trust has been created for a charitable purpose, and the intention of the donor has failed, either because of the failure to make a complete disposition in the beginning, or because of the subsequent failure of the original object, it will be given an application to the nearest approximate object. 111. On what ground do these two distinctions rest? First, on the favor due to charity, and that the primary object of the donor was to effectuate a charity, and second, to do so in a particular way, which is denoted by the trust. 112. What two doctrines arise from the application of the Cypress doctrine? 1. That wherever intention is manifested to appropriate a fund to charity, the gift will be effectuated in exclusion of a resulting trust. If however, it does appear that the donees of the fund were to take in exclusion of the charity, then the doctrine will not be given effect. 2. An application to some other purpose than that specified, being as close to that object as possible, will be given. 113. What is meant by a charity of a compound character? Whenever a fund is given for a particular or definite charitable object, and there arises a surplus after the completion of the gift, this surplus is to be applied by the Cypress doctrine and is said to be of a compound character. See Attorney General vs. 1 Say, 15 Vs. 231. Adams, 72, 114. What is an eleemosynary corporation? One established by charter for charitable purposes, having endowments for that purpose, and subject to the jurisdiction of a court of equity as to the mere management of the estate, and not to the election or remotion of the incorporators or the internal administration. 115. When does the jurisdiction to compel specific performance of a contract arise? Wherever a contract binding at law has been infringed, and the remedy by damages is inadequate. 116. What are the requisites of a contract to entitle one to specific performance? 1. That it be a valid, binding contract at law, i.e., on a valuable consideration. 2. That its mutual enforcement in specie be practicable. 3. That such an enforcement be necessary. 117. What is meant by the mutual enforcement in specie? That it be such a contract as the defendant can fulfill and that the fulfillment on his part and also on the part of the plaintiff may be judicially secured. Marbleco vs. Ripley, 10 Wall, U.S. 339. 118. What is meant by the enforcement being necessary? It must be important to the plaintiff and not a hardship on the defendant to compel this enforcement. 119. Explain what is meant by not being a hardship on the defendant. That wherever the plaintiff has a remedy at law, although he shows a necessity for the actual performance of the contract, yet if a wrong would be inflicted upon the defendant by going beyond the ordinary remedy, greater than that which would be suffered by the plaintiff, then the court of equity will refuse to interfere. 120. What are the three subordinate equities under the head of specific performance? 1. Part performance. 2. Allowing time to make out title beyond the day specified. 3. Compelling a conveyance with compensation for defects. 121. What is the equity of part performance? When a contract for the sale of real estate has been made verbally, and the vendee has entered upon the land by reason of the contract of sale, and has so injuriously altered his possession as that he cannot be restored to statu quo, then a court of equity will enforce the performance of the contract, even against the statute of frauds, 29 Car. 2. On the ground of preventing a fraud. 122. What do you understand by the equity of allowing time to make out title beyond the day specified? At law, time is of the essence of the contract, but in equity it is not so considered, and whenever a right arises under a contract and the performance is not made at the time, but a substantial performance may be had by an extension of time, a court of equity will allow such an extension. Brown vs. G. T. Co. 128 U.S. 403. 123. Is time ever of the essence of a contract in equity? It may be made so by the parties, but the mere fact that a time has been specified for the completion of a contract, does not, of itself, make it essential. 124. What liberty is given the vendor under this equity? He is allowed to make out a title at any time after the commencement of the suit, or even before final decree, subject to a liability for the costs. 125. What do you understand by allowing a conveyance with compensation for defects? A sale of an estate has been made and because of the failure of title to part, or on misdescription of the property, it cannot be literally performed. In such cases, if the diminution or loss be small, a court of equity will compel the conveyance with a compensation for the part which has failed, although at law the contract could not be enforced. 126. Does this equity apply most strongly in favor of the vendor or of the vendee? In favor of the vendee, who may compel a conveyance of whatever the vendor has, but the vendor cannot compel the vendee to take if it is shown that it was necessary for him to have the whole. 127. Does the doctrine of specific performance apply to chattels? Generally it does not, unless the chattels be of a peculiar value to the owner. McGowan vs. Remington, 12 Penn Street, 56, Pissy vs. Pissy, 1 Vern, 273. 128. What are the remedies at law for an unlawful detainer of chattel? 1. Trespass for unlawful taking. 2. Trevor for unlawful conversion. 3. Detainee for actual detainer, and sometimes, assumpsit, in cases where treven may be waived. 129. What is the doctrine of election? The right to choose between two benefits, where the person can be entitled to one only, and it usually arises in cases of dispositions by will, where the testator gives property of his own, and by the same instrument attempts to dispose of property of his donee. 130. Give an example. X dies and by will leaves to Y. Lot 1, in square 2, and also leaves to Z. Lot 2 in square 1, which latter property belongs to Y. In this case Y is put upon his election, and must either relinquish his own property or compensate Z. Fitzhugh vs. Hubbard, 41 Arc, 64, Gorham vs. Dodge, 122 ill. 528. 131. What two things are essential to originate this equity of his donee? 132. How does this equitable doctrine of election differ from election of remedies? The first arises only in equity, while the second is applied at common law to the right of suit. In either case when made, it binds the parties and their privies. Smith vs. Gilmore, 11d. C. App. 145. 133. Is the doctrine of election applicable to dower? Yes, wherever a post-nuptial jointure or settlement has been made, or a disposition by will to the wife, she is entitled to take either under the jointure or will, or to reject either and claim her common law dower. 134. How must an election be made? It may be either by express words or by acts and conduct from which it can be implied, and if no election be made voluntarily, it may be compelled by a decree. 135. What right has the person making the election to be informed of the value of both interests and, if a bill be filed against him, to compel an election? He should be fully informed as to the value, and may file a cross bill, to have an account taken and the property ascertained. 136. If a person be incompetent by reason of infancy, coverture, insanity or the like, how could his election be compelled? In such cases the Court of Equity will itself make the election by reference to the master for inquiry as to what would be for the best interest of the person under disability. Benhallow vs. Kimball, 61 N. H. 596. 137. What is the effect of election on the property? It does not divest the property out of the donee, but binds him to deal with it in such manner as the court shall direct. If electing to relinquish his own property, he must convey, or if to retain his own, he must convey the estate devised to him to the disappointed donee or compensate him for the value thereof. 138. What are the two classes of consideration at common law? 1. Good, such as natural love and affection. 2. Valuable, such as money and the like. 139. What is meritorious consideration in equity? Performance of a mere moral duty, and is confined to charity, payment of creditors, and maintaining wife and children. 140. What is the doctrine with regard to meritorious consideration? That a promise made without a valuable consideration cannot be enforced against the promiser nor against anyone in whose favor he has altered his intentions. But if a gift on meritorious consideration be imperfectly executed, and the intention remains unaltered at the death of the donor, it may be enforced against all persons not having an equally meritorious claim. 141. What are the principal applications of the equity? To supply surrenders of copyholds against the heir, and supporting defective execution of powers against the remainderman when the defect is formal. 142. What do you understand by the maxim equity imputes an intention to fulfill an obligation, and what is its application? That wherever a person is under a moral duty and does an act which reasonably may have been meant in satisfaction of that duty, he is presumed to have so intended, i.e., a purchase made by one person in the name of another would be held as an advancement in the case of a child, but as a resulting trust in the case of a stranger. 143. On whom is the burden of proof in such cases? In the case of a stranger, it is on the person who alleges that he was to take beneficially, while in the case of a child, it is on those who allege he was to take as a trustee. 144. Is parole evidence admissible in such cases? Yes, as the question is always one of intention, and there is no rule of law which prohibits its use. Miller S. Appeal, 107 Pennsylvania Street, 221. 145. What is the distinction between legacies to strangers and those to children? In the case of a stranger, the legacy is considered as a mere bounty, and dealt with under the ordinary rules of law. In the case of a child, it is presumed to that presumption. 146. From what time does a legacy bear interest? If no intention is expressed, it bears interest from the time fixed for payment, and if no time is fixed, from 12 months after the testator's death, but if it be a legacy to a child, from a parent, and no other means of maintenance provided, interest will be allowed from the time of death. Marsh vs. Taylor, 43 N. J. Ec. 1.